Good morning, Rebecca. Thank you for meeting me here today. How are you?
I'm good, thank you. How are you?
Good, thanks. So my name is Liam Broadby and I'm a licensed conveyancer here at Whitehaven Conveyancing Services. So the purpose of today's meeting is to discuss your proposed purchase of 271 Ocean View Lane in Rosetta.
Yep.
And I understand that you're wanting to offer $925,000. Is that correct?
Yeah.
Yeah, great. So during our meeting here today, we'll cover items that should be in the contract and your rights and obligations under that contract. We'll also discuss some documentation that you'll be signing throughout the conveyance process. And I'll also let you know of the likely costs involved in the property purchase, which will include like the purchase price, the transfer duty, and all likely costs. And I'll also discuss the transfer of land, and also a caveat and also the next steps required to progress your purchase matter.
Yeah.
Now, just a heads up, this meeting is being recorded for assessment purposes. I just want to make sure you're okay with that.
Yeah, I consent. That's fine.
Yeah, great. No worries. So before we begin, are you able just to confirm whether you are looking to live in the property or if it's an investment property? What's making you want to purchase this property?
So I will be moving into it. It'll be my primary residence.
Yeah, no worries at all. And is it just yourself purchasing?
Yes.
Great. And is it a trust entity or is it just in your individual name?
Just in my individual name.
Yeah, no worries. Now, in relation to your finance, how's that progressing? Have you started those conversations with a broker or a bank at all?
Yeah, I have pre-approval.
Yeah, no, great. Well, thank you just for letting me know that.
No worries.
Now, another clause that there is a section for it in the standard form RIT contract of sale.
Yep.
In relation to building inspections, have you thought about having a building inspection on the property?
No, but I would like one.
Yeah.
If that's possible.
No, absolutely. I would certainly recommend including a building inspection clause in the contract once you do receive a copy from the agent, because you haven't got a copy of that yet, have you, that contract?
No, not yet.
No worries at all. Well, just moving on, I just want to let you know some key principles for a contract to be considered legally binding.
Yeah.
So a contract to be considered legally binding must have offer, acceptance, a consideration, an intention to create legal relations, capacity, and the legality, meaning the contract must be lawful. So in your case, your signed proposal to the purchaser to purchase property for $925,000, that would be the offer, and satisfying that principle. Now, if the vendor accepts that offer, that's the acceptance, satisfying that key principle. Now, the consideration principle, that is you offering the $925,000 in exchange for the property. So you're exchanging that money and the vendor's exchanging the property. Now, entering into a contract of sale, both parties, their intent is for it to create legal relations. Now, obviously, I assume you have capacity. And the vendor as well. So both parties must have capacity to enter into a contract. And lastly, it just must be lawful. So the terms in the contract must abide by all the relevant laws. So just letting you know, the property advertisement is generally an invitation for purchasers to make an offer rather than the offer itself.
Okay. And am I legally bound as soon as it's signed, as soon as I sign it?
Yeah, so your signature will constitute an offer. So as soon as you put your signatures onto that contract, you offer that to the vendor. And if the vendor accepts those proposed terms and that's communicated to you, also subject to the wording of the contract and the conditions contained within it, then you would be considered legally bound by that contract, and what you have offered, you are legally bound to. So for that reason, I would not sign anything until we've reviewed the contract in its entirety and until you receive this final advice from ourselves. So does that sound okay so far?
Yeah, absolutely.
So just letting you know, in Tasmania, there's no general statutory cooling off period like there is in other states on the mainland. Which means you should therefore not sign on the assumption that you can simply just withdraw your offer. So protections to cover that are either conditions included in the contract, which give you a certain amount of time to withdraw from the offer, or alternatively, we just do our investigations before you enter into a formal contract. Yeah, so, and moving on to finance, because you have pre-approval, I would certainly, and because you are relying on finance to fund the purchase, I certainly recommend including a finance condition within your offer. Now, the finance clause should state, one, the loan amount you're applying for, the time period and who you're applying with. Now, we'll give you further advice for when we're assisting you in completing the contract. However, our advice is that in terms of the financier, we title that a lending institution of your choosing.
Yep.
That way you can, if you do get declined for finance, it could be any lender and you can provide a decline letter. And also in relation to the amount you require, we would usually recommend putting sufficient funds to settle. And again, this means that, within a reasonable amount, you can terminate on finance if you don't have finance, basically.
Yeah.
Now, in saying all that, you must make a genuine attempt to obtain finance, which means you must make reasonable endeavours to satisfy that clause. So if you don't have reasonable endeavours to satisfy that clause, you then may be in breach. So it's really important that in order to terminate the finance clause, you must have made reasonable endeavours to satisfy the clause.
Okay.
So if the bank declines the loan, we must follow the applicable notice requirements and deadlines in the contract in order to terminate the contract. Does that make sense in relation to finance?
Yeah.
Great. Now, in relation to the building inspection, again, I would certainly recommend having a building inspection to make sure that property is suitable for what you want it to be. Now, in the building inspection clause, where again, you need a time frame, we typically recommend 10 days. That usually gives enough time for a building inspector to attend the property. Now, you must also include a defect limit. Now, this means that basically, under the building inspection, you can't just go, I'm not happy with that building inspection report, I want out. It's not as simple as that. You need to set a defect limit. So we usually say about 2 to 3% of the purchase price. Which means, let's say, for example, if the defect limit was $15,000, and a building inspector says, there are more than $15,000 of defects in this property, then you could terminate the property, contract, assuming that it must have a proper certifications that the building inspector must include within their report.
Okay, and what happens if I waive finance and then the bank later refuses the loan for whatever reason?
No worries at all. So you would generally remain legally bound to settle. So if you couldn't provide the funds, you would be in breach because you've already waived finance and assumably the building inspection clause has already previously been satisfied. So the contract would have been unconditional. And because you could not complete settlement, you would be in breach. Now, being in breach carries many consequences, including the vendor terminating the contract, you forfeit your deposit, and they could also sue you for any legal damages that's caused by your breach. So that is a main reason why I suggest certainly not waiving any clauses if you're unable to. So if you don't have finance, do not satisfy finance clause will always be my recommendation. Now, is that all making sense?
Yeah, absolutely.
Great. So in relation to some rights and obligations, so the vendor must transfer the property in accordance with the contract and provide the title free of any mortgages and encumbrances, apart from interest disclosed as remaining on the title, such as some easements or some covenants. Now, we will examine the title to make sure that the title is compliant. And we'll make sure, so let's say, for example, we notice that there's a mortgage on the property, we will ensure that is discharged at settlement to ensure that you don't carry that moving forward once you're the owner of the property. Now, unless the contract states otherwise, the vendor must also provide vacant possession, which means if the property is currently tenanted, they are obliged to ensure that tenant is moved out of the property before they can proceed to settlement. So I recall you were wanting to move into the property, that's correct?
Yeah, that's right.
Great, so we'll make sure that that property is being provided for vacant possession, and when we get a copy of that draft contract, we'll make sure that also reflects that. Now, the vendor also, so in Tasmania, unlike the mainland, where there is appropriate disclosures that the vendor must complete, in Tasmania it's buyer beware, which is another reason why it's very important that you obtain this advice before entering into a contract. So let's say, for example, there is a vendor warranty section within the contract, and we'll detail that to you once we see the offer, once we see the draft contract, sorry. However, most of contracts are sold without qualification, which means that if any issues do arise in our council searches, such as a shed not being compliant with council, then you have no grounds to terminate, and that would become your issue. So Tasmania, it's not very, doesn't protect many buyers, so it's very important that you obtain that advice. Now, as the purchaser, your main obligations are to comply with the contract. So, for example, pay the deposit within the due date, which is typically 3 days. In relation to the deposit, we usually recommend 5 to 10% of the purchase price. Also, obligations are ensuring that the balance of the purchase price is paid at settlement, along with the necessary adjustments. Also, again, complying with the conditions, so making sure you obtain finance and booking in that building inspection, and also just completing settlement on the contractual settlement date. Now, if you don't settle on the agreed date, the vendor may be then able to issue you with what's called a notice to complete.
Okay.
Now, notice to complete gives you an extra 14 days to settle. However, if you don't settle within that period, they can then grab your deposit, terminate the contract, sue for any legal damages. So very important that we comply with the terms. Is that making sense?
Yeah, and just what happens if either party doesn't comply?
Yeah, no, of course. So if the vendor breaches the contract, you do have the same rights to issue that notice to complete. This is if it turns unconditional. However, you're not able, there's obviously no deposit to be claimed. But you have the other rights in terms of terminating the contract and suing for any damages caused. So you might be able to seek some compensation and recover your own deposit.
Yeah, okay.
So if you breach the contract again, we've discussed that, so you might forfeit the deposit as well. Now, if the vendor breaches the contract before it's unconditional, let's say they have an issue a title clause and they didn't make reasonable endeavours, then again, you might be able to sue for any damages caused by that breach. However, in saying all of that, the exact remedy would depend on the wording in the contract. And also the seriousness of the breach, which would mean that we would certainly need to review any contract as well.
Yeah, okay, that makes sense.
So throughout the conveyance, you will need to sign multiple documents. So the first is this contract of sale, which we've been discussing here already. So the purpose of the contract is to record the exact property that's being purchased, the purchase price, the deposit, and any special conditions that you wish to include within your offer. Now, once that vendor accepts your offer and acceptance has been communicated with you, that's when the contract's considered legally binding, and that's when all parties start to work towards fulfilling those conditions as well. Now, following this, we'll then need you to sign our engagement and cost documents, which are set at the beginning of the matter before we progress any further on your matter. Now, these documents instruct us to act on your behalf and also explain the work we'll perform, and we'll also detail the costs involved. So basically, once you sign those documents, we then progress in representing you in the matter. Now, as per some new legislative requirements, we're required to now verify your identity, which you would also do with your agent and your bank. You have to verify your identity to everyone to make sure you're a real person. Now, it's in place to protect you. So for example, if you went to sell the property, it's to ensure that you are the one selling it and someone's not acting as you. So it helps against fraud and confirms that you are authorised to give us instructions. Now, another document is a client authorisation form. Now, this instructs us to prepare and represent you and also sign on your behalf. And is a requirement as per the Land Titles Office. So that will be another document that you'll need to sign. Another document will be any transfer duty documents and also our client instruction form. So our client instruction form will instruct us, again, to act on your behalf with all your information to allow us to prepare the necessary documents. And also any transfer duty documents. So if you're going for any exemptions of duty, that would be some other documents that you would need to complete to support the duty assessment. And now that's all the documents with our side of things, or at least most of it. The other thing is you would also need to sign any loan and mortgage documents with your bank. However, that would also need to be discussed with your broker to understand what documentation you should be completing.
And will I need to sign a paper transfer?
Yes, so as of a year ago, yes. However, new legislative requirements have come in and Land Titles Office are now removing the need for clients to sign transfers. And now, as in Tasmania, we're progressing into settling via an electronic platform called PEXA. We will sign the transfer on your behalf, and the client authorisation form that you will sign will give us permission to do so on your behalf. Now, is that all making sense? Great. So just moving on to some costs involved in the conveyance. So our professional fees are the charges for the conveyancing work that our firm performs on your behalf. Now, these costs would include reviewing the contract, providing you with necessary advice, conducting searches, preparing documents, and also ultimately arranging settlement and settling your purchase. Now, our estimated professional fee will be set out in writing in that cost disclosure, and you'll be required to sign that to ensure you do accept those instructions. Now, it's our professional fee. The disbursements are slightly different. So these are payments made to third parties or government authorities on your behalf to ensure settlement is occurred. Now, this may include, in terms of disbursements that we'll pay for, it'd be such as title search fees, council search fees, land tax fees, any searches and fees required for settlement to be completed. And there'll also be the government charges, being the filing fee on the transfer to register property in your name, the filing fee on the discharge of mortgage, which will actually be paid by the vendor, and also stamp duty.
Okay.
Now, the difference in professional fees and disbursements are that professional fees are the work that we perform on your behalf, while disbursements are those payments to third parties.
Okay, yeah.
Now, GST generally apply to our professional fees. However, they're not always charged on government charges and disbursements, such as the transfer filing fee. There is no GST payable on that.
Okay, yeah.
Is that all making sense as well?
Yeah.
Yeah, no, great. So under Schedule 1, Clause 2 of the Conveyancing Regulations 2025, where we accept your instructions, we must provide you with written information about the costs expected from you in order for the transaction to occur. So this must include an estimate of the total costs and the method of which that's calculated.
Okay.
So as soon as practicable, after the matter is completed, we must also provide you with a final settlement statement showing how those funds were dispersed.
Yeah, okay. And could the cost increase?
Yes, possibly. However, that would only occur if unexpected work was required, such as resolving a title issue or if there was another unexpected issue. However, we would explain that ahead of time. It wouldn't cost you on top automatically. That would be discussed, and you would be aware of that cost should you have to pay it.
Yeah, okay, that makes sense.
No worries. So in Tasmania, stamp duty is more commonly known as property transfer duty, which is payable under the Duties Act 2001 and is administered by the Tasmania State Revenue Office, also known as the SRO, but most people call it the State Revenue Office. So duty is generally calculated on the higher of the purchase price or the unencumbered market value. So the dutiable value. So let's say, for example, if you are purchasing with a real estate agent, stamp duty will be payable on that purchase price. And that's deemed to be the dutiable value. However, let's say I was to sell a property to you and you wanted to purchase it for $500,000. However, the market value is $800,000. You're deemed to have to pay the purchase price on the dutiable value, which would be the market value, unless you can prove otherwise by way of an independent valuation.
Okay.
Now, so the State Revenue Office have their own way of calculating stamp duty, which is, you can see that on their website. However, just by a quick calculation before you come to the meeting here today, stamp duty is about $37,000. So has your broker factored that in at all?
Yes, I have.
Great. So just to let you know, there was a first home buyer's duty exemption, which applied to property being purchased under $750,000, and settlement had to occur prior to the 30th of June this year. There's also other requirements in relation to being an Australian citizen. But however, in this case, obviously, the exemption won't apply as the settlement will be occurring after that date and you're purchasing for more than $750,000.
Yeah.
And just to confirm, you are a first home buyer, aren't you?
Yes.
Yes, that's a bit annoying that they removed that, but hopefully there's some sort of government compensation coming soon.
Yeah.
But so just to let you know, in relation to duty, it's payable within 3 months under that Duties Act. 3 months of the dutiable transaction. Now, as part of the settlement process, we do complete what's called a transferring transaction certificate, which does a duty assessment. Now, although the stamp duty is payable within 3 months, your bank will most commonly want that at settlement. So again, although it's payable within 3 months, it's usually payable on settlement. So we'll need to make sure those funds are ready to go. Now, in saying that, if for whatever reason you couldn't pay the stamp duty in time and the bank allowed you to pay it within that 3 months, if you were to not pay that within 3 months, late payment of the stamp duty would result in interest being charged by the State Revenue Office, which on previous matters which we've had is not cheap at all. Yeah, so do you have any other questions at all?
Yeah, do I pay that duty directly?
Yes, so it will be included within your settlement statement. So depending on how much your bank is offering, we'll either get that all from the bank. We'll either get you to transfer that to our trust account, or we will ask you to put it in a nominated shortfall account, should that be something you nominate with your bank when you're completing those loan documents. Is that something you've discussed with your broker at all? Shortfall? Yeah, great. Now just moving on to some documents we will prepare on your behalf. So just letting you know, after you enter into a legally binding contract, you generally acquire what's called an equitable interest in the property, although you're not technically the registered legal owner as yet. Now, a way to protect your equitable interest in a property is a caveat, and we'll lodge it on the property title. So that what a caveat does, it alerts where it's registered on the title,
Yep.
and it warns someone wanting to claim an interest in the land. So its purpose is to protect the claimed interest, being you purchasing the property,
Yep.
which it prevents any other person lodging and registering documents.
Okay, yeah.
Now, under Section 133 of the Land Titles Act 1980, a person claiming an estate or interest under an unregistered dealing may lodge a caveat.
Yeah.
So your interest as a purchaser under a binding contract may be capable of supporting one, but a caveat should only be lodged where there is proper legal basis to do so. So we will ensure that you do have the legal right to lodge one.
Yeah.
Now, to lodge a caveat, we must prepare that approved form for you, which is approved from the Land Titles Office, and that caveat will include the affected title, so the property title. It'll have your details, also the estate interest that we claim under that title, and the basis of which we do make that claim under.
Okay.
So it also must be properly signed and lodged with the Recorder of Titles, being the Land Titles Office, and if accepted, that caveat will be showing on the property title, and the registered owner will be alerted of that caveat being lodged.
Okay, and will we definitely lodge one?
Most likely. However, we would first consider whether there is a genuine risk of your interest and whether the contract provides sufficient legal basis to lodge a caveat. The reason being is an improperly lodged caveat may delay dealings and expose yourself to liability.
Okay.
So just to let you know, a caveat may be voluntarily withdrawn or removed by court order or allowed to lapse. So if a prohibited dealing is lodged and the recorder serves a notice, the caveator, which will be yourself, you generally have 28 days to obtain and serve a Supreme Court order preventing registration of the other dealing. Otherwise, your caveat would lapse. So does that make sense in relation to the caveat?
Yeah.
Great. So just moving on to the other documents. So there's also the transfer of land. So that documents the change of ownership between, so it transfers the ownership from the vendor to yourself. Now this should reflect the title particulars to ensure that the correct title is being transferred, and it'll also have information such as your full name, where you intend to move into the property, the purchase price, and also how you wish the property to be owned. So let's say if you're purchasing in capacity as a trust, that would be noted, or if you're purchasing with a partner, whether how you wish those interests to be reflected would also be reflection on the transfer.
Yeah.
So for an eligible electronic transaction, which your transaction will be occurring via PEXA, which is an electronic platform, we'll prepare and lodge the transfer through that approved electronic platform. Now at settlement, the balance of the purchase price would be paid, the vendor's mortgage would be paid out, and then that transfer would be registered to register property in your name.
Okay, yeah.
Now just to let you know, because this is something that some people don't think about. So although the contract gives you the contractual and equitable rights beforehand, you don't become the registered legal owner until the property title is actually in your name. This transfer and registration process is governed by the Land Titles Act 1980. Now, the Land Titles Office are currently taking 3 months to register any dealings, which does cause complications, especially with councils issuing rates notices, for example. So there is a bit of that wait for you to be registrable owner of the property, although you are technically the owner and you'll be living in the property.
Yeah, that makes sense.
So as your conveyancer, I will firstly review the contract and also the titles, and also review the council searches that we receive. And I'll also order those required searches to ensure the property is fully compliant. Now, if there are any issues with the title documents or the searches, I'll advise you of those concerns and provide preliminary advice and guidance as to best how to approach those concerns. We'll also monitor the finance and building conditions, making sure they're being complied with. We'll handle all the communications with the vendor's representative and also book in your lender in for settlement. We'll prepare the duty and settlement documents and calculate the necessary adjustments, as well as confirm how much we require from you. And we'll also arrange settlement and attend settlement on your behalf, which will be done by the electronic platform. And also just ensure that all documents are ready to go for lodgement. Now, are you happy with all those?
Yes.
No, great. So in accordance with our firm's procedures, my supervisor, who is the director of the business, they'll review the file and all documents before settlement is completed. Now, this is a routine quality control to ensure that no mistakes have occurred throughout the process and make sure the documents have their appropriate information and signatures included. Now, this provides an additional level of protection for you because, we are all human. So it provides that second double check to ensure no errors have occurred.
Okay, yeah.
Now, after settlement is completed, we'll provide you with a final letter detailing that settlement has been completed, and we'll also notify the relevant authorities, being the Glenorchy City Council, as you're purchasing in Rosetta, and also the Taswater. We'll notify them and any other relevant authorities that settlement has been completed and that you are the new owner.
Yeah.
Now we'll also attend to registration to ensure the documents have been registered. Now, as I advised, land titles office are taking 3 months to register anything, so there will be an ongoing monitoring of that. However, once registration has been completed, I'll forward an electronic copy of the title for you, so you can retain for your own records. Just so you know, the title then goes to the bank and they hold that for the duration of your mortgage.
Okay, yeah.
Now, just to summarise what we've discussed here today, so I've recommended that you should include a finance and building inspection in your contract to best protect your interests. You must also pay the deposit, arrange finance and settle on time, so meaning you must abide by those terms of the contract that you accept. Now, the vendor must provide the title and vacant possession as agreed. You also need to complete some legislative requirements such as verification of identity and a client authorization form. And also you'll need to sign our cost disclosure statement to ensure you're happy to proceed.
Yeah.
Now, in terms of stamp duty, I've advised that it's around $36,000 to $37,000. However, our cost disclosure statement will confirm that amount for you.
Yeah.
Also, a caveat must be or may be lodged to protect your interests, and we'll manage the transaction through to settlement on your behalf. So before we conclude our meeting here today, do you have any questions for me?
Yeah, I suppose just what do you need from me next?
Yeah, no, of course. So I'll firstly just need, your contact details. So we'll send you an email after our meeting advising you a summary of our meeting and also advise you what we need from you.
Yep.
However, just while we're here, I will need, again, your full contact details, also your identification and your broker's details so I can communicate them as to how your finance application is progressing.
Yep.
Also some confirmation in regards to how much you're applying for and how much they think you need for finance.
Yep.
Also who you're instructing for building inspector. We do have recommendations, so please let me know if you do want me to recommend anyone for you.
Yeah.
And then also we'll need to just assign our initial engagement letters, which will be provided in due course. So, and also just confirmation that you do want to proceed with the purchase contract.
Yeah.
So once you do have a copy of the draft contract from the real estate agent, feel free to flick that through to us.
Yeah.
We will then review that on your behalf to make sure that there isn't any weird clauses that the vendor wants included.
Yeah.
And then before you sign, we will provide that advice to you as to how best to fill that out.
Yeah.
Now, I expect to provide an update in relation and a review once receiving the draft contract within 1 to 2 business days. However, it could be sooner, just depending on where it comes through on that date. So does that sound okay?
Yeah, absolutely.
Great. So thanks so much for meeting me here today. Do you have any final questions at all?
No, not yet, but I'll email you if I do.
Yeah, no worries at all. So like I said, we'll email you very shortly after our meetings. But if you have any questions at all, feel free to contact myself. You have my number.
Yeah.
And I suppose we'll be in touch.
Perfect. Thank you so much.
No worries at all.